And we are live. Welcome to a special edition of CryptoLawTV. I am John Deaton, the founder and your host. And today is arguably the best day in crypto. It's certainly the best day in crypto in the last 3 years. I got to tell you, even Ripple haters, XRP haters, are saying great job. They're saying, I never thought I'd say this, but thank you, XRP. We got the decision today, as all of you should know by now. And the one thing that I really feel validated about, believe it or not, is my faith that Judge Torres, along with Judge Netburn, were the good judges. If many of you remember, when we got the judge, because you don't know which judge you're going to get in the Southern District of New York or many other districts. And when we got Judge Torres, I did a little research. I read a couple of her summary judgment decisions. I saw that she had been critical of the Department of Justice in the past. And I saw a judge who sort of ignores the bullshit and ignores the noise and just applies the law. And at the end of the day, that's what you want. And a judge who's not afraid to call it something out, to call the government out if that's what needs to be done. And so to a lot of the people who were so frustrated about how long it took, who started doubting her and doubting, is she in bed with the SEC? Hopefully you have a little bit of faith restored. Okay, that we had a judge who applied the law. And when you apply the law objectively, you get the right decision in this case. Remember what I said before. I said that early sales of XRP in those early days could be construed as an investment contract, but that this approach that selling them in the secondary market, buying it off Coinbase or Uphold or Kraken, that those were also investment contracts, that's nonsense. And today, that's what we got. And so I'm going to take you through the opinion real quick and highlight a few things. And yes, XRP holders are cited. The judge cited all the amicus briefs that she read them all. Spin the Bits, XRP holders, Digital Chamber of Commerce, all of the ones that were submitted, because this is a conscientious judge. And XRP holders' affidavits, I'm going to show you how they made it into this opinion. And so I want the people to feel good about themselves, right? People who waited patiently, people who participated and took the time to sign an affidavit, get it notarized, who didn't mind their name being out there, who wasn't fear of retaliation by the government, who said, I just want to have my voice heard. Well, your voice got heard, and I can show you what I mean by that. So let's go through the opinion real quick. An exceptionally concise, well-written, well-analyzed decision by Judge Torres. Very methodical, very simplistic. She stuck to the facts and the law and gave her decision. And if there's one thing, I can only think of one criticism, and I've only read it through once, and I'll share that in a minute. But let's go through it real quick. She starts off with showing that she understands that the XRP ledger was an open source. She talks about how anyone can access it and utilize the ledger, send a value over the ledger. That's important. People can run a node to be part of the validation process. And she talks about how there are independent developers who are on the XRP ledger that have nothing to do with Ripple. She doesn't say it in those exact words, but she does say other developers. The way she says it is other developers have built software products that use the XRP ledger, such as payment processing applications. And I know one of those developers was Spin the Bits, which is a payment app on the XRP ledger, completely independent from Ripple. And so this is a judge who took her time to learn these things. And she talks about how XRP was meant to be a better version of Bitcoin. And she goes through that history. And then she says, you know, the XRP ledger is based on open source software. Anyone can use the ledger, submit transactions, host a node to contribute to the validation of transactions, propose changes to the source code, or develop applications that run on the ledger. And so that's how it starts. And then she gets right to the point and says, listen, at the end of the day, the question here is, did Ripple violate Section 5 of the 1934 Securities Act? And she basically takes the SEC's summary judgment, where they basically, in the complaint, they do this as well. They break down, in essence, 4 categories of sales of the XRP by Ripple or their founders or the 2 executives. So the first type of sell is called institutional sales. And that's basically to hedge funds. And what's interesting about this decision is that, and I'm going to explain to you, Judge Torres rejects the Ripple argument of essential ingredients and the pre-1939 blue sky laws argument. She says, hey, you can't cite one case that's ever cited this essential ingredients. It's outside of Howey. I'm not going to go outside of Howey and apply something else that the Supreme Court itself hasn't applied. Very rational decision. But what's interesting is she says, I'm not even going to get to the issue that you have to have a written contract before you can have an investment contract. I don't need to get there, because the only sales of XRP that I find to be unregistered securities are the ones with written contracts. So she goes, I'm not even going to go down that road because I don't need to, because all the ones sales of XRP that didn't have contracts are not securities. And so fascinating the way that she lays this out. And I personally, I've heard people talking about, oh, it's going to get appealed immediately by the SEC to the Second Circuit, and it could get overturned. You know, theoretically, could it get overturned by the Second Circuit? Sure. And then it'll go to the Supreme Court. And with the Supreme Court, but this is very difficult to overturn, in my opinion. There's going to be people that disagree with me, but they cannot basically criticize her for the reasoning, in my opinion. Now, that's the institutional sales, right? And then there was a second kind of sell, which are through exchanges. They're called programmatic sales. Basically, Ripple is selling XRP through Coinbase or any other exchange. And she makes note that those sales are blind sales, the bid and the ask, right? You don't know. We don't know when we go on Coinbase who we're buying XRP from. We don't know whether it's Ripple. We don't know whether it's, you know, a founder. We don't know whether it's Moon Lambo cashing out at $4, some of his XRP. We don't know who it is. And so how can you rely on the efforts of the other when you're unaware of who that other is? Sort of some common sense applied here. But the institutional sales, the first category I told you, the SEC said Ripple raised $729 million. The programmatic sales, which are on the exchanges, was $757 million. And then you have this third category called other distributions. Basically, it's Ripple paying contractors or developers or even employees XRP as compensation. And that's the other one. Well, Ripple, the SEC said, raised $609 million selling XRP to third parties through these other distributions. And then the fourth category of sales was Brad Garlinghouse and Chris Larson selling in their individual capacities, not as Ripple, but as individuals, their XRP on exchanges. And that Chris Larson sold $450 million worth US dollars, and Brad Garlinghouse sold $150 million. And now Brad Garlinghouse and Chris Larson had a defense, which was that their sales were in foreign jurisdictions. where XRP is not a security, and therefore there's no jurisdiction here. The judge in a footnote says, I don't even have to get to that. And the reason I don't have to get to that is because I'm finding that Chris Larson and Brad Garlinghouse sales of XRP on exchanges where it's blind, you don't know who, the buyer doesn't know the seller doesn't know the buyer. That's not a security. Just like when Ripple sold on exchanges, that's not a security. And so the only sell that was deemed an unregistered security was the institutional sales, hedge funds. Now, the one criticism that I would have is that in her opinion, she basically defines institutional sales as sales to hedge funds and ODL customers. And I think that should be distinguished because we all know, and Bill Morgan has been someone who has been very vocal about this, more so than me and other people. So make sure that he gets credit for that, which is that ODL, because the ODL customer sells the XRP back after a few seconds, that how do you rely on the efforts is not an investment. It's just a transaction, but the judge just grouped it in there. And so that's one potential problematic area. Whereas in the future going forward, is the SEC going to try to, make hay with ODL cells? And so that's the only thing after my first reading of this decision that I saw as potentially problematic in the judge's analysis, because I really don't think ODL cells can be grouped as same as selling to a hedge fund who really is relying on some efforts of Ripple who are going to sell it later for a profit. Okay, so that's basically, she lays that out, and then she just goes over a few facts. She talks about the marketing that Ripple did, and you could tell the judge brings up things that I brought up in the amicus brief, which is, listen, Ripple sent a brochure to 100 people. If you can prove those people bought XRP relying on the promises and marketing of Ripple, then go at it. That's a direct sell from Ripple. But some brochure that was sent to 100 people in 2014, or some Twitter statement that Chris Larson said in 2015, when many XRP holders, the 6 XRP holders that were individually named that I represent, not one of them were on Twitter back then when those Twitter statements were being made. So you can't basically just take some statements and then apply it to the world. And the judge basically, in so many words, took that to task. And so the judge talks about the legal memos after the marketing. She then says that she read all of the amicus briefs. And then she takes the next few pages and she dismantles Ripple's essential ingredients case and test that they wanted to invoke. And so that's in essence what happened. Now, the thing that I want people to know is that the judge rejected Ripple's argument about essential ingredients and you have to have a contract, but ultimately the only sales that were deemed unregistered securities were the ones where there were written contracts. And in those written contracts, there were restrictions on selling, and there were other things that the judge said clearly. And what she did with all those different types of sales that I just told you, the institutional, the programmatic, on the exchanges, and then the other distribution to employees as pay. She literally takes each one and she does a Howey analysis for each one. And when we get, for example, to the others, giving XRP to your employees, the judge says that doesn't meet the first prong of Howey. And then says, since it doesn't meet the first prong of Howey, I don't even have to get to the other prongs. It's just not, they didn't pay any money for it. She also talks about how Ripple used XRP for third parties, or Ripple gifted XRP. I think that's important because of airdrops. There's no money spent for airdrops. And so I think that there's some good stuff in there for other types of cases as we move forward, or arguments. And so then the judge absolutely does what the judge in Library wouldn't do. You know, in Library, we said, Judge, you shouldn't have to, but can you just make it clear that the token itself is not a security? Well, Judge Torres hits it head on, and she goes on and she says everything that I and other people have been saying from the beginning. The underlying asset is not the security. It's never the security. The orange groves weren't the security. The beavers weren't the security. The Bitcoin wasn't the security. The chinchillas wasn't the security. The whiskey receipts weren't the security. Just like XRP is not the security. And the judge made that clear. And then she says, she actually talks about something that I talked about a lot of times. Remember when I said, if just because the Howie orange grove, you relied on Howie and you entered a common enterprise, but then if that person died and their estate sold the orange grove, it wouldn't be an investment contract, especially if the person had no knowledge of the Howie stuff. And Judge Torres actually talks about, for instance, if the original orange groves in Howie were later resold, those resales may or may not constitute investment contracts, depending on the totality of circumstances surrounding the later transaction. What's that mean? Many of you seen me battling a few people on Twitter who say I was wrong when I said that you have to apply Howie at each sell. That's what an investment contract is. And I said there's not a single case in the history of the United States where there's no privity between the promoter, issuer, and the buyer, and there was an investment contract. And there's not a single case in history where the second sell was deemed also an investment contract just because the first one was. In fact, the only case that dealt with it said otherwise. And that's basically what the judge says here. So for those people that I was battling, could you please shut up? Because I'm tired of arguing about that. To me, it's common sense. And what kills me is some of them are securities lawyers who've been doing this for 10 years, 20 years. I've been a security lawyer for what, 2 years? So there you go. Now, the judge also talks about, quote, each transaction must be analyzed. That means each sell. Okay, so just because Ripple sells to a hedge fund and that's an investment contract doesn't mean that when that hedge fund sells it to Coinbase or on Coinbase to you or me, that is also an investment contract. It's not, okay? Or it certainly isn't per se. The judge goes on to say what we've all know, even if XRP exhibits certain characteristics of a commodity or a currency, it may nonetheless be offered or sold as an investment contract. Again, any asset can be marketed, packaged, offered, and sold as an investment contract. The judge cites what I said. I predicted this one. I said that when people said, well, just because the library judge didn't, I said, Judge Castell is in the Southern District of New York. He handled the Telegram case. He's friends with Judge Torres. And I said, he said in Telegram, as you all know, that the Graham purchase agreements and the Graham token itself is not a security. It's just alphanumeric sequence. It's software code. And Judge Torres cites the Telegram case where the security in this case is not simply the digital token, Graham, which is little more than alphanumeric cryptographic sequence. Okay, and so that's what she does, and she dismantles that. Let's see what else we want to talk about. So the judge with the institutional cells said that the hedge funds paid for the XRP, first prong met, investment of money. She said a common enterprise existed between the hedge funds, these institutional buyers, and Ripple, because Ripple had a written contract with them and they're making certain promises or assertions or conditions, and that these hedge funds are clearly relying on those statements by Ripple, and that there is horizontal commonality, blah, blah, blah. Basically, she says, so that was met, and that those institutional buyers were relying on the efforts of Ripple. And therefore, Howie was satisfied. But she goes on to say, just because there was a common enterprise between the institutional buyers and Ripple doesn't mean that you and me are also in a common enterprise with Ripple. All right. Or that the entire XRP ecosystem and all of that nonsense that the SEC's expert witness was saying that the SEC was trying to say. Remember, XRP represented the investment contract. We're going to get to that in a minute. And XRP represented the common enterprise. So what else? She distinguishes that. And basically everything that we've been arguing. Remember, from the very beginning, when I filed a writ of mandamus, I said, if you limit it to direct sales by Ripple, then we don't have anything to say. If someone buys it from Ripple based on what Ripple told them, then maybe you can meet Howie. But when we buy it on Coinbase or Uphold or wherever else, many of us who never heard of Ripple when we first bought it, don't argue that we're in a common enterprise relying on the efforts of a company that we don't even know anything about. Okay. And so that's basically what the judge held in this case. The direct sales by Ripple to these institutions satisfied Howie. She goes on through there. Now, one thing I want to highlight, and I sent a email out earlier, which was in footnote 16, the judge, because I did a podcast or a show where it was on Twitter, and someone said, John, do you think that the Judge Torres is paying attention to what's going on in LIBOR? And I said, absolutely. And we know that for sure now, because footnote 16, the judge cites that January 30th transcript when I was in the hearing on behalf of Naomi Brockwell and was arguing with not arguing with the judge, but pleading with the judge. Can you clarify your ruling? And the judge promised that he was going to do it. Now, he didn't follow through on that promise. We know that. But when Judge Torres wrote this decision, that order wasn't out. So she relied on that transcript, and she cites the very page and lines of the transcript where the judge said to me, I'm going to make sure that to clarify my order does not apply to secondary market sales, because the judge says in this footnote, she cites that hearing and says the judge declined to extend his holding to include secondary sales. And so I just point that out is because I said we have to fight whenever there's a court hearing or there's an issue where we can be heard, where we can create a record, we got to do it. And I think that proves that all of this is related. Now, I want to go to page 24, because this is where I can tell you for sure that XRP holders made a difference. And, you know, I got to tell you, I haven't watched it yet, but I heard that Moon Lambo did a video today, and that in the first couple minutes that he got quite emotional. And I can understand that. And I want you to feel validated, because a lot of people said, why are you doing this? Why would you go out on a limb? You're never going to make a difference. Whatever's going to happen is going to happen. You can't fight the government. You can't win. You can't do anything. It's useless. And, you know, we were arguing that you either don't fight or you fight, and you fight. So on page 24, the judge says that when she's talking about these programmatic sales, she says that, in fact, many programmatic buyers, now these are buyers on Coinbase or Uphold, these buyers were entirely unaware of Ripple's existence. And then she cites where she's relying on that information, and she cites ECF numbers 831-1-831-26. And that are the XRP holder affidavits. That's the 3,500 affidavits that we submitted to the court saying, hey, you know, some of them said, yeah, we knew about Ripple when we bought XRP, but I didn't rely on them. But there were also thousands that said, listen, the first time I acquired XRP, I may have knew the word Ripple because it was used interchangeably, but I didn't know that there was this company called Ripple that sold software to banks. I had no idea when I bought XRP. So just think of it from a common sense perspective. How can you rely on the efforts of a company that you don't know exists? And that's basically what the judge is articulating here. And that's something that we fought hard to include in our brief. And so that's great. Let's see what else we go over real quick. Also, she talks about what we wrote in the brief as well, in our amicus brief, where she says these statements, there's no evidence that these statements from 2013, 2014 reached the general public. So SEC, you can't make a connection to these people who are buying it in the secondary market on Coinbase or Uphold or with Kraken or wherever. You can't make a connection that just because they made these statements on a YouTube channel or a Twitter handle, or they were at a conference and said something in 2015 that, you know, James Rule XRP read it and said, oh, let me buy some XRP, or anyone else out there in the world of XRP. So she made a big deal about that. And so let's see. Anything else I want to highlight? I do want to note that Bill Hinman testified, because this shocked me, in his deposition, that he believed that you did not need to meet all factors of Howey. He actually said that in his deposition, and I really scratched my head at that. And Judge Torres says in footnote 18, because the court determines that the record does not establish the first Howey prong as to the other distributions, that's the employees getting paid, the court does not reach whether the second or third Howey prongs have been satisfied, which means all three prongs, and remember the third prong has two elements, must be met, or there's no investment contract. Okay. Now, then she goes on and says the same analysis applies to Chris Larson and Brad Garlinghouse. They sold on exchanges. It's a blind sell. People don't know who they are. So the same rationale applied to Ripple selling exchanges applies to them. They're not securities. Hard stop. Then she gets to basically, so she finds summary judgment in favor of the SEC on the institutional sales, the ones with the contracts. And then she finds summary judgment on behalf of Ripple for the programmatic sales on the exchanges, for the individuals, executives selling it, and for the other distributions. Okay, Ripple wins there. And then she basically says that leaves me with the recklessness, aiding and abetting of the two executives. And what she did was very consistent with her ruling. And she struck the fair notice defense. But a lot of people are arguing and saying it incorrectly. She didn't reject the fair notice defense in its entirety. She said the fair notice defense was inapplicable to institutional sales. All right. As a matter of fact, there is a footnote where she makes it distinguish. And right here, it's footnote. It's on page 29, footnote 20. She says, because the court finds that only the institutional sales constituted the offer and sell of investment contracts, the court does not address defendants' asserted fair notice defense as to the other transactions. She says the court's holding is limited to the institutional sales because the SEC's theory as to the other sales in this case are potentially inconsistent with enforcement in prior digital assets. So what she said is that the fair notice defense is inapplicable to the institutional sales with contracts because the law is clear with them, and that the SEC's prior enforcement actions are consistent with that. So she's striking the fair notice defense on that issue. She says, though, that if she would have ruled the others, sales were an unregistered security, then the fair notice defense could come into play. All right. So I just want to make that distinction because I haven't seen anyone make that distinction. They just said, oh, she struck the fair notice defense. Okay. But on those institutional sales, then the judge simply said, look, since there is no fair notice defense on institutional sales, then there is a jury out there. I'm not going to grant summary judgment to the SEC because she said there's a reasonable jury out there that could find that Chris Larson, Brad Garlinghouse were not reckless. That when you look at the legal memo that they saw, when you think about the FinCEN settlement that they were under, when you look at those things, those are fair game to defend against aiding and abetting. In other words, a jury could find that they're not reckless because that's a higher standard. And so that goes to a jury. And that's the part that goes to the jury. And basically, that was the decision in a nutshell. There's been a lot of confusion too about, and I want to try to find it, about secondary sales. Because she says that she's saying secondary market sales are not before her, which means that if she were going to apply a Howey test, she has to apply it to each transaction. And so maybe a secondary sale hypothetically could be a security, depending on what was communicated and all those things. And maybe it's not. And so she's not going to reach that. But she said that selling on exchanges, and she actually said that the programmatic sales are basically sitting in the foot, or however the saying goes, I don't have it in front of me, but she's basically saying that you stand in the secondary market where you don't know who the seller is. And if you don't know who the seller is, how do you rely on them? And so she de facto commented on the secondary market sales by saying XRP is not a security, right? The token itself is not a security. And these secondary transactions on exchanges, even when Ripple sells it, are not securities. Even when Brad Garlinghouse and Chris Larson sell it, it's not a security. So if Ripple and its executives are selling on an exchange, and those are not investment contracts, you can see how she really is kind of commenting on the secondary market sale. So I understand her ruling completely on why she said that comment. I'm not going to comment because it's not before me. But when you read that decision, it's clear secondary market transactions. Now, the point being is that the SEC is going to have to prove that Coinbase, that maybe the person was relying on Coinbase or any of these things. And so this decision is great news. And I want to play a clip because it's already caused some things. And I want to remind people of what Paul Graywell said on Crypto Law.
But one thing I want to assure you and assure all your followers is that this is not a decision that is set in stone. And once the courts issue sufficient clarity in the form of a ruling or a decision, we will not hesitate to revisit that issue.
We will not hesitate to revisit the issue. Well, guess what? Coinbase has already decided to relist XRP. When I started this live stream, we were still waiting on Coinbase, but it was already live on Kraken from what I understand. And so to their credit, I remember the chief legal officer of Coinbase saying, hey, we're going to not hesitate to relist it if the language is clear. Now, if we got the judge from Connecticut, we may not have had that clarity. But because we got a judge who applies the law and the issues before her and isn't afraid of certain things, you know, I don't want to be too critical. I'm just saying is that we got a good judge. And I've always said that, and she proved it today. And it's a fantastic decision. They're so great to see XRP holders so excited, to see them happy, to see a good day in crypto. And I want to say that thank you to those out there who kept the faith. It takes a lot to hold on to XRP for this amount of time, with this much FUD out there. When this case was first filed, we stood alone. That's a fact. We stood alone. Okay. I got ridiculed publicly. Who's this crazy guy filing writs of mandamus 9 days after the lawsuit against Ripple? Laughed at. XRP holders were abandoned, and we united. And 75,000 of you came together and said, we're going to unite, and we're going to stand as a community, and we're going to fight. And today, you won that fight, and you deserve all the credit for it. I can't thank you enough. So many people, and I don't want to turn into Moon Lambo tonight and start crying. Sorry, Matt. I just don't want to do it. But I can't tell you how much your appreciation for me means to me. It means the world to me. So thank you. But you deserve the credit just as much as I do. I look forward to my steak dinner, Charlie Gasparino. And tomorrow, I'll be on Charles Payne, I believe, to talk about this case and to talk about this great victory for XRP holders first and foremost, but for crypto in general, because this case has ramifications. Listen, if you saw what Gensler and the SEC said today, they're praising it like they won. This is a huge blow. There were emergency meetings at the SEC, guarantee you today. Great news for Coinbase. Imagine these exchanges are relisting it within hours. What's the message there? And finally, I think this is a huge blow to Elizabeth Warren and Gary Gensler and their anti-crypto campaign. We desperately needed this. We needed a judge to just look at it objectively, not favor one side, call balls and strikes the way they are. And that's what we got. And I said, we're going to win in the end. And today was a great day. And so enjoy it. You deserve it. And victory is ours. See you next week.